I've been through the rain, I've been through the storm, I've been through the pain, and it's hard to stay calm. Yeah, I bet the sun gon' shine on me. It's gonna shine. I bet the sun gon' shine on me. It's gonna shine. I've been through the rain, I've been through the storm, I've been through the pain, and it's hard to stay calm. Yeah, I bet the sun gon' shine on me. It gonna shine. I bet the sun gon' shine on me. It gonna shine. All of the pain inside, it's hard to let the shit ride. Homicide, homicide, why they take my nigga life? Seems I got some shit with my family, I'm trying to get it right. 2 daughters, 2 mother, 2 family, that's right. This the shit I live for, I keep that shit they kill for. Try to kill my spirit, yeah, my music what I heal from. Keep that weed coming, cause I ain't trying to feel nothing. That shit broke my heart when I caught my cousin stealing some. Tell me why me, when I'm really trying to build some. Fed some young niggas, little bitches set me up, huh? Should've killed them niggas since then, I done triple boy. Probably 25 to life, I pull it from my hip, yeah. I've been through the rain, I've been through the storm, I've been through the pain, and it's hard to stay calm, yeah. I bet the sun gon' shine on me. It's gonna shine. I bet the sun gon' shine on me. It's gonna shine. I've been through the rain, I've been through the storm, I've been through the pain, and it's hard to stay calm, yeah. I bet the sun gon' shine on me. It gonna shine. I bet the sun gon' shine on me. It gonna shine. April 11th, I lost my pops. 10 months later, my daughter dropped. And you can't tell me life can't transform. And you can't tell me that I ain't the one. I done took blows from friends and family. I done made money with friends and family. When you get broke, just watch it and handle it. It's time to ride. And niggas ain't down for you find that fire. And then you start rapping, you find that plug. And then you start stacking.
Yo, what's good, beautiful people, man? Welcome to In God We Trust Academy podcast. How you guys doing out there tonight? Where you tuning in from? Let us know where you're locking in with us from right now.
LRP and we way up in God. I've been through the storm, I've been through the pain, and it's hard to stay calm, yeah. I bet the sun gon' shine on me. It's gonna shine. I bet the sun gon' shine on me. It's gonna shine. I've been through the rain, I've been through the storm, I've been through the pain, and it's hard to stay calm, yeah. I bet the sun gon'
Like, share,
shine
and
on
subscribe,
me.
family.
I bet the sun gon' shine on me. It gonna shine.
Yeah, man. Hope everybody's doing good tonight. Such a perfect and beautiful night as always, man. All honor and glory go to God, and we give thanks for you guys and your time, as you can be doing anything. But if you're scrolling and you stop here, that means that this is meant for you tonight. And tonight we're going to be talking about saving you, your family, or someone from foreclosure. What is it that you can do? And even if you ever been foreclosed on, what if there was a surplus that was made from the selling of your house? You were supposed to get that money. So we're going to talk about these things tonight that happens a lot. And people, well, they forget to assert their rights. And when they don't assert their rights, that means that they literally choose not to act upon them and waive them and fully agree to any and all procedures that has been set forth. Right? So we want to make sure that everybody fully understands this tonight, right? We got a few special things going on right now. We have a credit warfare package on InGodWeTrustAcademy.com. The donation is $75. There's a replay and an ebook to go to that. And you also get a raffle ticket that goes with that to give you a free chance to win the 2026 Toyota Camry that will be given away February the 21st, 2026. We also, in God We Trust Academy right now, they have a half off on the full trust setup. The donation is $600 now, so you will get a full trust setup at that cost, full consultation, step-by-step guide with you as well, okay? Yes, and that will extend for about a week or so. So we'll see how. And also, we got season 6 of Work Sessions that is up now for sale. It's half off as well. So you can go get season 6. Comes with ebooks and things of that nature and replay as well. But it is half off to you guys that is interested. All right. So what's up, man? How y'all out there doing tonight? Y'all locked in? Y'all loaded? Y'all ready to learn something? If so, drop some ones. Let me know you in here with us tonight. Or am I by myself? You know, you never know. Am I by myself? I doubt it. Somebody always listening. Somebody's always watching. So we're going to speak to you guys today. So when it comes to foreclosure, what is foreclosure? And before you accept threats and all of these different things, and you know that you're about to come to a forefront of foreclosure, you need to start gathering evidence about whom the plaintiff is that is trying to bring something against you. Evidence is going to be your best friend in this situation. No, there's not a status correction or anything like that you need to do. It's just for you to have the mindset and understanding of the law and the procedures of the court and how they have to prove delegation of authority. So we have to start also making these people pay for the things that they do. We cannot keep letting people get away over and over and over. Anytime that there's any type of harm, dispute, etc., y'all, in commerce, monetary damages is there all times, every time. Every time. They cannot waste time. They cannot waste money. They cannot waste a lot of stuff. They cannot cause harm, defamation, any of that, right? So we need to be very, very keen on these things today. So first, let's establish what is a foreclosure. So a foreclosure is a legal process by which a lender reclaims a property after a borrower defaults on their loan. So when you purchase property using a lender, the right to foreclose is established from the moment you sign the closing documents. Okay? There's two documents, right, that has to be present. The promissory note, which is a legally binding promise to repay the loan, and the mortgage, which is the deed of trust, which is a security instrument that allows the lender to seize and sell the property if the borrower defaults. So what this means is this. That means that they have to have the promissory notes first to claim that you defaulted in payment. And then they have to have the deed of trust, which is the security instrument, in order to foreclose on the house. If they separate those at any time and don't have either one of those, then they don't have the power to do such thing. If they don't have the note, then they can't declare a default in payment because they don't have that obligation or delegation of authority to do so. If they don't have the deed of trust, that means that they cannot foreclose on the actual house, especially during the time of their claim. See, it doesn't matter if they done it that later down the road. What matters is when they made their claim, were they fully authorized to do so? Right? That's what we're going to be focusing on. So how does the foreclosure begin? The lender pays the seller the purchase price in return. The seller signs the deed over to the buyer, and the seller walks away with the lender's money. The buyer takes possession, but the lender has a security interest in the property until the loan is repaid. So when you sign the closing documents, you agreed that failure to make payments or meet the loan terms allows the lender or whoever holds the documents now to take legal actions to foreclose and reclaim the actual property. Okay? So the core legal principles of this here is foreclosure stands or falls based on the promissory note and the mortgage. So no lender or servicer can foreclose without proving ownership of both the note and mortgage. They have to be able to prove a right and interest to do so. So, if a party cannot produce these documents in court, they have no standing to foreclose. So, without a legal standing, foreclosure must be dismissed. Now, not only that, it also means that the lawyer has to also show that they have a right to delegation of authority to bring this claim on behalf of the company as well. Okay, and they have to show that they was given this authority through some form of board meeting, etc. Right? Has to happen in that way. Okay, so if a party cannot produce the documents, they have no standing to foreclose. Without legal standing, foreclosure must be dismissed, and it's really that simple, family. But you have to understand the procedures of the court. So many lenders sell or transfer loans, meaning the original bank no longer owned the note and mortgage. Foreclosure defense strategies often close on forcing the lender to prove it legal authority to foreclose. Well, here's what happens, guys. They sell the note so many times and so fast that they don't necessarily go and do the deed of trust until after they want to try to do a full foreclosure on you. That's the thing. So make sure that you understand that, especially if they're going to do a non-judicial foreclosure. So, and that's how they always get caught with verification that they don't have the chain of title, or they don't have where they were given the rights, titles, and interest, like a chain of title showing that this was given to them. They never have it, right? So they have a lack of standing, which means the lender must prove its original note and mortgage. The chain of title issues, which means any missing assignments or fraud in transferring ownership, invalidates foreclosure. All right? So they have to be able to show that. All right? Any assignment, anything, any transferring, we want to see it. So now we got a right to see the securitization. Now we can see the securitization documentations electronics as well, but you got to know how to literally bring those things to court, make them produce those documentations. And we're going to talk about that as well. So it's what you have to do. Okay. So improper notice and procedures, lenders must follow state-specific foreclosure procedures. So make sure that you fully understand the procedures, guys. One thing about people is that humans and people are lazy, right? They're lazy. They get lazy. They cut corners, whatever the case may be, especially when they're used to doing something so much. They're used to people being ignorant, and, and there's not going to be any form of pushback, or you don't have the money to get a lawyer, or you just don't know what's going on. So people get very lazy, okay? So they're not going to fully follow procedures when they do stuff. I guarantee it, okay? They're going to go usually hire the most cheapest lawyer it is. They used to cutting corners anyway, so there you go, okay? So a borrower who understands the principles can effectively challenge and delay foreclosure, or even force the case to be dismissed. Now, here's my point. If the case has to be dismissed because the lawyer never got full delegation of authority, then you should immediately do a counterclaim, because that means they were acting fraudulently, and then now that you should be able to fully sue them for your time, for any form of things that you had to put off in your life, maybe even, go and seek counsel or whatever the case may be, right? You see what I'm saying? So when you start seeing it from that perspective, then now you should know, like, y'all got to stop letting these people get off so easy. Yeah. You're not getting away with that. We had to come to court, and then you got a motion to dismiss. They dismiss it because they never showed proof of delegation of authority. Like, the lawyer couldn't prove that he had the power to bring the claim as well. So with that being said, you should sue. That's your time that's involved, right? That's your full time that's involved. So the court strategy is the lender must prove the right to foreclose, and the borrower must challenge their ability to do so. The lender wins if they can produce the original promissory note and the mortgage and prove the borrower defaulted as well. Or the borrower wins if they can prove the lender does not have legal standing to foreclose. The lender failed to follow proper legal procedures, and the borrower fulfilled their obligation or was wrongly classified as in default. Right? That's how you do it. So once you understand that part, these documentations are very, 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 very much so to ask for to make happen in production when you go to these courts. All right. You can literally do that. So the burden of proof is what the plaintiff must show. The party initiating foreclosure must produce the original promissory note. Now, you tell them why you need the note because they'll try to act like it's a copy of the contract or whatever, right? But no, you tell them you need it for examination. You need all documentations for production and examination. That's what you need it for. Right? So let's get it. Production, examination. That's what we want to make happen. All right. So now the original promissory note upon our examination, if they cannot produce it, what we'll do is proving they are entitled to collect on the debt. The original mortgage or deed of trust is proving their right to foreclose. So evidence of default is proving the borrower failed to meet the terms on the actual loan. So these are the burden of proof. So if the plaintiff cannot produce these documents, they have no right to foreclosure as well. So this is what you have to start taking in when it comes to these procedures, right? So using discovery, okay, to expose the weakness of the plaintiff's case. So we want to request productions of documents, but we need to be specific. Be specific in what you're asking for and what you want to be presented. Because literally we can get any and all documentations, the securitization, et cetera, all of that, you know what I'm saying, to go along with this. We can do that. We can literally declare that has to be fully given, okay? We got to be specific, though. Do know that. Like in Alabama Rules of Civil Procedures, right? And it's like Rule 34, and it's production of documents and things in entry upon land for inspection and other purposes. So when we want any form of writings, when we want any form of contracts, agreements, endorsements, we want custodial logs, we want assignment papers, services agreements, etc., no matter what it is, right? Excuse me. If we want those things, they have to be given. Tangible things such as the actual wedding signature promissory note, not any scanned copy, because we don't want that. Y'all excuse me. So inspection and copying. So we don't just want disclosure, okay? We want actual inspection. We want testing or photographing of the actual full original instrument. And then even then, photographing ain't gonna do either because we still need to be able to full examine it. Okay? That's another thing. So when you do a written request, you serve a written request identifying what you want produced. So we have to make sure that we describe it to the fullest. Like we want the original promissory note executed by the defendant on whatever date, including all endorsement, allonges, or assignments as well. And we can also implement that to be for securitization and everything else that's taking place. We want to be able to see everything. We want it all, yo. And see, here's the thing. In Alabama, it's already been done in a couple cases where they confirmed the court held that the plaintiff must demonstrate it was the proper party entitled to enforce the note at the time the foreclosure was initiated. Okay? Not later on, but when you initiate it. Sturdy versus Back Home Loan Services confirmed foreclosing party must prove ownership of the note and mortgage through admissible evidence. Gotta prove it. Perry versus Federal National Mortgage Association confirmed failure to show valid chain of assignments undermines standing. They got to be able to show, family. Got to be able to show full chain of title. We got to have it. So now that leaves us up to also send out interrogatories. We get to ask the lender to explain how they acquired the loan and prove their legal standing. Yeah, we get to ask them, how did you acquire the loan? And also prove your legal standing. Deposit the plaintiff's representative, make them testify under oath and gaps in the paperwork. So we can subpoena these people to the court. We can have depositions. If the lender cannot prove they have legal standing, you can move to dismiss the case. So some will try to include extra claims in foreclosure lawsuits such as unjust enrichment, claiming the borrower received benefits without paying, breach of contract, expanding the case beyond foreclosure as well. Challenge the legal basis of these claims. If they are improperly added, you can file a motion to strike them from the actual lawsuit. But not only that, y'all got to also remember that let's say you do get foreclosed on and at least you can tell them that you want the surplus. Yeah, that you demand the surplus. Because if they sell the house double for what it's worth and they make 100, like they get their money out of it, and then they still made like $175,000 off the house, of the sale of the house, that's your money. What's up, family? That's your money. And a lot of people walk away from a lot of money because they didn't tripled on your house. And you just abandoned the surplus. The surplus is yours. You got to remember that you said that you said that the home was yours to give in a security agreement. So you gave the home as your own property under a security agreement. And that when that security agreement was paid, et cetera, that they are to release the security back to you. So, and if they sell it in foreclosure, that means if it fulfills the full payment, then they still owe you the surplus. So a lot of people leave a lot of money on the table, even though they foreclosed on you, and they made over $200,000 off your house. And all you owe was $65,000. They got paid $65,000 and still made an extra 150, 70 some thousand off of it. You just let them walk away with your money. How? We got to stop doing that, man. That's why I say we be letting these people get off too easy with everything. Some judges, guys, will try to ignore the law and the rule of favor to the bank, even when the lender has not proven their case. But your job and duty is to preserve the record. And it's also for you to know how the court move, because as I said before, you do not have to sit in a court and go through harmful procedures. You can immediately go up to the next highest court right away. The next highest court you can go to, right? Which is the court above the one that you're in. So it's usually like the appellate court. And you can go there and ask for a mandamus or some type of prohibition, et cetera, injunction to be done to mandate the lower court to do something in your favor, which is equity, because they should have done it in the first place. So always make sure that we make a record. We ensure all objection and legal arguments are in the court transcript. If it's not a transcript there, at least write your objection and file it in on the docket. That's what you got to do. Be prepared for an appeal. Justice isn't guaranteed, but following the right legal steps forces the system to work in your favor. If the judges violate due process of law, you got the right to sue them under 18 U.S.C. 244 because they use color of law to deprive you of your right. We can't make it easy on them. That's all I'm saying. We can't make it easy on them. So remember, force a lender to prove the standing. We want to use discovery to expose gaps in their case. We want to challenge improper claims like unjust enrichment, and we want to make a record of everything. What's up, coach? Yeah, so that's what we want to be able to do. The record is the law. Got to beat them on the record all day long. And there's nothing they can do because the best evidence always rules, right? So a lender has to prove their right to foreclosure. If they can't, the case collapses. And I mean their right when they initiated their claim. When they initiated their claim is the day they send a claim to you threatening that they're going to foreclose, and they start coming after you like they have the right to come after you for some particular debt. From that beginning, from that day, and if you go look from the very first letter that they send you, making these threats to you, they made a claim when they made the threat. So you started acting based upon what their claim was, and you found out the day that they sent you those letters that they never had the right to initiate or make the claim or even seek any form of claim from you. So therefore, it's void ab initio, it's fraudulent, and you should be doing a counterclaim suing them and call it a breach of contract from that point on. That's a fact. So now we got to really make sure the two key documents is the promissory note and the deed of trust. These two documents are not the same, yet they work together to give the lender security over the loan. Many people mistakenly think they are interchangeable, but they serve distinct functions in property, financing, and foreclosure. The security agreement, which is the deed of trust, deals with the actual property, and the actual note is what deals with the actual loan, payments, etc. So a promissory note we know is a negotiable instrument, meaning it can be bought, sold, transferred, or assigned to another party. Whoever legally possesses the original note has the right to enforce the actual payment. Now, the thing is, if they get this note, but then don't go and put down on the deed of trust in the county that they have the security interest now, then they still have a default in their claim. They have a flaw in their claim, right? So the key to the promissory note is a promise to pay the principal amount, the interest rate, the repayment term, and the acceleration clause, right? That's what they're going to have, okay? So we know a mortgage is a security agreement that protects the lender. Unlike the promissory note, a mortgage has no financial value. It simply gives the lender legal authority to foreclose if the borrower defaults. But the only way they can foreclose if the borrower defaults is they have to have the note. Only way that they can foreclose for the default is they have to have the deed of trust. So if they don't got one or the other, they can't do one or the other. It's lacking their claim. So secure the loan with property gives the lender a right to foreclose. Tied to the promissory note cannot exist without it. Specific obligations, insurance, taxes, maintenance, responsibility, and the transfer of legal title or trustee in some of the states. The lender must have both promissory note and the mortgage to foreclose. There's no way around it. Okay? So when you buy property using a mortgage, you receive the equitable title, which is the right to use and enjoy the property, while the lender actually holds the legal title until the loan is fully paid. Okay, so you got the equitable title, borrower, the legal title, lender. Once the mortgage is paid off, the borrower receives both the legal and equitable title. So therefore, that literally closes the trust. Okay, so any foreclosure principle, a lender forecloses based on the mortgage, not the actual promissory note. Okay, so who can foreclose? This is what's important. Only who holds the note and the mortgage. The original lender can foreclose if they still own both documents. A new entity can foreclose if they legally acquired the note and mortgage. They have to legally acquire it. Y'all would be surprised how most of the time, man, The title holding company is the one that they end up holding it and ain't transferred it and sent it nowhere to nobody. You'll be surprised how many times that happens. All you need to do is just check the dates. And if it's never been transferred to the individual, et cetera, or at the time that they made their claim, they didn't have it, no way. That's how you win, right? So if a bank or servicer cannot prove it owns both, it lacks standing to foreclose. And this is the key defense borrowers can use to stop the actual foreclosure. So a borrower can fight foreclosure. We can do it by proving the lender cannot produce the original note, the lender lacks a valid assignment of the mortgage, and the borrower did not default, and the lender failed to follow foreclosure procedures. Okay? Also, you can get them like this. If they take you to civil procedures through a court without taking you to arbitration, well, that's a form of material breach as well. So that is a breach of contract. It actually kills out the contract. And if they take you to civil claims before taking you to arbitration, you should not do a motion to dismiss because the contract says it must be pushed to arbitration. So you should not. Most people ask for that in equity. Me, you wasted my time and you did something that was fraudulently outside of the actual corporation. I mean, not the corporation, but the contract. So since you did that, I got to get some money. We got to get monetary damages on here. You see what I'm saying? How do the HOA, home association people foreclosing without both? Because nobody challenges. That's how. Man, make them prove that. We'll take it all the way to the Supreme Court to prove it if we have to. But that goes back to you have the right to face your accuser. Who's your accuser? What are their claims? And what evidence do they have to bring their claim against you? They don't got it, then it's a little situation for them. So remember, original note, we're gonna challenge any form of improper assignments. All right. Any payment errors that they do, we can show. We can force the plaintiff to prove that standing, and the lender cannot prove the right to foreclose, then guys, they're going to lose. They're going to lose. So, in order for us to win a case, we got to make sure we got a strong affirmative defense that forces the plaintiff to prove they have a right to foreclose. We need to demand a strict proof that plaintiff possesses the original promissory note. And we want to say, we got to say the reason why we want this to happen. The reason why we want it to happen is because we want to have the right to examination. Okay? And disclosure. Okay? We don't want to just see it. We want to fully examine it. That's why it needs to be brought here. All right? So, we want to be able to do that because remember, they do robo-signing. They'll take your name and sign them on other contracts. They'll do all kind of stuff. And that is found often, very often, more often than you could ever imagine. Right? So demand strict proof that the plaintiff possessed the original note and mortgage or legally admissible evidence proving their right to enforce them. We're going to use discovery to obtain and challenge evidence, forcing the plaintiff to produce authenticated original documents proving their legal standing. And we're going to make sure we have to object to any judicial errors on the record, ensuring you have a valid basis for appeal. We have to be able to do that. And having all proceedings transcribed by a court reporter, ensuring there is a complete record of any misconduct, errors, or abuse of discretion by the judge. If not, you must fully make note of it yourself. So that's why I say, if y'all in any place and there's not a court reporter there, then if you do an objection in the court right then and there, then you need to make sure that you put that objection in writing and timestamp it at this particular, you do an affidavit. Do an affidavit, place it in there. You were there at that particular time, place it as evidence on the court record, and there you go. That's all you got to do. Now it becomes part of the actual docket itself. So now you are preserving the record for going into the appeal. You got to make sure because they do all kind of stuff. Okay? So having all proceedings transcribed by the reporter as well. So your affirmative defenses should clearly establish why the plaintiff foreclosure action is legally defective. All right. So courts typically require that the affirmative defenses be filed along with your answers. So failing to include them at the outset can weaken your position. So let's make sure that we put a defense and an answer there. So that means if you made all your payments on time, you must state defendant made all payments in full and timely manner when due. All right. Once you assert this, you must follow up with discovery to obtain evidence such as receipt, bank statements, and transaction records that proves your claim. So other common defenses include lack of standing. The plaintiff is not this is the affirmative defense. So the plaintiff is not the legal holder of the note and mortgage, improper assignment. The chain of title for the mortgage and the note is broken or fraudulent. Failure to comply with state foreclosure laws. The plaintiff did not follow legally required foreclosure procedures, which they do. I keep saying that. So know the procedures. Telling you, due process of law is on your side, guys, at all times. Statute of limitation, the foreclosure is barred due to time limits on enforcement. So always list your defenses and the facts you intended to prove rather than just citing legal terms like estoppel or unjust enrichment. Your defenses should include factual allegations that you can support with evidence. Okay? Now, we can also do what we call request admissions. Admissions is a powerful tool to force the plaintiff to admit or deny key facts. So if they fail to respond properly, you can move to have the request deemed admitted, essentially winning part of your case by default. So you can say, admit that you do not possess the original mortgage document alleged in these proceedings. Admit that you do not possess the original promissory note alleged in these proceedings. Admit that the attached copies of checks and composite Exhibit A were properly endorsed and negotiated by the plaintiff. And you can say, if the plaintiff fails to provide a valid response, file a motion to have admission deemed admitted and set a hearing. So courts are generally strict about compelling responses to admissions. So a failure to respond properly can be a major advantage for your cases. So do a writ of do a motion for admission. Absolutely. Because if they can't prove it, then they must admit it. If you didn't produce it on the record here, then admit that you don't have it. All right, we'll go that route. Well, you're right. We don't have it. It's here in such and such. So how can you have the right to delegate, to have the right to the claim, to bring this claim today? And they don't. They can't prove it. So the demand for production of key documents. Remember the note, not a copy. We don't want a copy. Okay, we want the actual original for examination. Okay, all assignments of the mortgage and notes, tracking ownership back to the original lender, and we want evidence of any breaches of contract, such as records proving missed payments or default notices. If the plaintiff cannot produce the documents, they lack standing to foreclosure. Okay, and you can move forward to dismissal. Many foreclosures rely on robo-signed documents and fraudulent assignments. So forcing production of original can expose major legal defects. So do know that all day long. So produce all documents evidencing your right to act upon the conditions stated in the promissory note tendered by the defendant. And if they fail to provide valid response, and you got to remember what we're saying. We want them to produce all document evidencing your right to act upon the conditions stated in the promissory note. So they have to be able to show those. Right? Use interrogatories to expose plaintiff weaknesses as well. So interrogatories is where we get to write questions that forces the plaintiff's authorized representative to answer under oath. These questions should be carefully crafted to force the plaintiff to admit gaps in their claim. So what we want them to do is we want them to identify all individuals with personal knowledge of the facts alleged in your complaint, including their job titles and addresses. So now we want to know everybody who got firsthand knowledge. We want to identify all assignments of the mortgage and note, listing the dates of assignments and the parties involved. We also want them to list the full securitization process, all companies or trusts, etc., that is fully involved as well. of the transferring of the note and explain how you have firsthand knowledge of the alleged default by the defendant. Many foreclosure cases are filed by banks without a direct representative who actually knows the details of the case. And if the plaintiff cannot provide meaningful answers, you can challenge their credibility and move to strike their claims. As always, because the lawyer doesn't know, he wasn't there. So he only got a he say, she say. Yeah, and they got to prove that they have the right to bring it, right? So we also got deposition, where we get to question the plaintiff representatives under oath before trial. Okay? So never take a deposition, though, before you have exhausted all written discovery tools. After we've done every written discovery tool we're supposed to use, then we'll get into deposition. So deposition is depose the person who verified the foreclosure complaint. Force them to explain how they obtained knowledge of the case and use written discovery responses to expose inconsistencies. Get to ask these questions, right? If the deponent contradicts previous responses, you can impeach them in court and destroy their credibility. So you can say, you are hereby notified that the defendant, John Doe, will take the deposition, all right, of bank representative name at the law and firm on whatever date and time, and the witness is required to bring all original documents requested in the attached subpoena. So let's go sit down and ask them some questions. And the first thing we're going to say is, hey, we want to see that note. You got that note with you here today? Can you get it? Do you have it? All of that good stuff. So if the plaintiff fails to respond properly to discovery, you must file a motion to compel, and if necessary, move to dismiss their claims. All right, we can do that. We can do that. Okay. We can win easy. Production. We want the note. We want all assignments of endorsements. We want everything about the securitization. We want the full chain of title of how many times the note was transferred, how at what discount was it sold, what are the proceeds. Yeah, we want to know the whole entire nine. And this could literally save you from both, whether it was judicial or non-judicial. When it comes to non-judicial estates, what you guys got to do is this, because they don't have to literally take you to court. So if you know that they're coming after you, then immediately go do a petition to injunction or do a declaratory judgment, either or. But me, I would do an injunction. Okay? Because the minute we do an injunction, right? The key to stopping a non-judicial foreclosure before it occurs is to seek a temporary injunction, a legal order that pauses foreclosures proceedings while the court reviews the case. And this allows homeowners the opportunity to invoke their discovery rights, forcing the party attempting foreclosure to produce admissible evidence that they have the legal standing and right to foreclose on you. After securing temporary injunction, homeowners can use the discovery process, such as interrogatories, requests for admissions, production of documents, depositions, subpoena duce tectum, which is we can make sure that certain documents of these particular companies, et cetera, get fully produced to us so that it can be up under our examination to make sure that this individual or whatever servicer or whoever's making the claim had the right to make the claim at the time that they made the claim, right? So it'll expose any defects in the foreclosure claim. If evidence surfaces proving that the entity attempting foreclosure lacks the legal authority to enforce the debt, the courts may grant permanent injunction preventing the foreclosure altogether. Now, once that happens, guys, once you get the injunction, you should immediately go and sue. After you got the injunction, take that injunction order, turn around, and go and sue. Literally, because they just wasted your time. They made all these threats and did not never have the delegation of authority. So you had to take them to court. You spent all of this money. They got court fees. You got all this type of stuff going on. So now you need to sue. You shouldn't waste no time at all. The foreclosing party lacks standing. The entity attempting to foreclose does not have the note or mortgage. The entity cannot provide admissible evidence of a valid transfer or an assignment proving it is the holder in due course. If they just come in there with the contract, with a copy of a contract, and then they come in there with a ledger, y'all, it's over with. And they didn't come in there with the deed of trust that's not presented. You see what I'm saying? And then if you have a trial that's not there to be presented to you, so you can ask for those things. Let me do a full examination. Because they can disclose a copy of, but no, we need to do an examination. I need to make sure that's my signature. I need to make sure there was no anything else added to this contract that I wasn't aware of or whatever the case may be. If they lift your signatures, they do that. So now we're going to look for the chain of title on the mortgages. We're going to contain gaps, inconsistency, or fraud, and the mortgage and note have been satisfied. The debt has been paid in full as well. All terms of mortgage have been fully complied, and the lender or servicer has improperly applied payments, resulting in a false default. That could happen. Why the court must review the foreclosure claims is because, unlike judicial foreclosures, when lenders must prove their right to foreclose in court before proceeding, non-judicial foreclosure bypasses the court process altogether. Because of this, many homeowners never get an opportunity to challenge fraudulent, wrongful, or improper foreclosure. And that is the purpose of filing an injunction before the foreclosure proceedings begin, is to bring the case before a judge who can ensure the foreclosing party is acting lawfully. Again, either an injunction or a declaratory judgment. So once in the court, the homeowner gains access to the full, to powerful legal tools such as discovery and all the tools that you're going to need that's in your favor to make them prove. Okay? We're going to make them prove. Justice is about balance. A just court will not reward an unjust plaintiff, but it also will not reward an unjust defendant. So let's make sure that we're right in our things. So we can do a petition for temporary restraining order and preliminary injunction to halt non-judicial foreclosure sale. And we're still going to go into the same thing. We're going to say that they have a lack of standing, there's an improper assignment, failure to provide proper notice, lack of compliance with mortgage service rules, defendant failed to comply with the state and federal loss mitigation requirements, including review for loan modification alternative as required as well, right? You can do it that way. So the injunction will definitely help you stop and bring it to a halt, because that's what you want to do. But we just got to be mindful to ask for these things because they're not going to have it. At least to fine for a true title, agreed. I seen you talking about the warranty, express warranty. Yeah. Agreed. All of that goes at hand. But it's our duty to make sure that we fully ask for these particular things that we want to be brought forward to prove in our defense, is what I'm saying. Because if I read, let me go to this right quick. I'm going to show you what this say. Let's see, Alabama. How much will we sue them for? Man, you tell me. How much was your time for? You ought to have, they wasted your time. You can ask, you can always put a number out there. And then the judge will say what he think is reasonable from there. But I always throw a number out there for what I feel, regardless. Pay me my money. Real talk. Throw your number out there. I know I would every single time. What if the house is in a private trust? Well, that means you need to know how to intervene as a trust. That means so you need to know how to intervene as a trustee. If it's in a private trust, then now you have to go in and motion to intervene as the trustee because the trust now has the interest in it. And or you need to do it, bring up the petition in the injunction in the trustee's name. If you do it in the trust name, they're gonna make you have to get a lawyer. You don't want to go through all that unless you just want to. I mean, you know. All right, so look, I'm finna read these procedures for you guys. All right, so any party may serve on any party a request to produce and permit the party making the request or someone acting on the requester's behalf to inspect. So that's what you want to do. You want to inspect the original to know that the copy is valid. Okay, you got a copy, you got to test or sample any designated documents or electronically stored information, including writings, drawing, graphs, charts, photographs, sound recordings, images, and other data or data compilations stored in any medium from which information can be obtained, translated, if necessary, by the respondent through detection devices into reasonably usable, or to inspect, copy, test, or sample any designated tangible things that constitute or contains matter with the scope of Rule 26B that are in the possession, custody, or control of the party upon whom the request is served, or to permit entry upon designated land or other property in the possession or control of the party upon whom the request is served for the purpose of inspection and measuring surveying. So again, we want the documents for inspections. So they can't give you a copy when you need to inspect the original to validate that the copy is actually true. Right? So the procedure, it says the request may, without leave of court, be served upon the plaintiff after commencement of the action and upon any other party with or after service of the summons and complaint upon the party. The request shall set forth the items to be expected either by individual item or by category, and shall describe each item and category with reasonable particularity. So you have to be very specific on what you want to see. Okay. The request may specify the form or forms in which the electronically stored information is to be produced. The request shall specify a reasonable time, place, and manner of making the inspection and performing the related acts. Okay. There you go. We got the right to request these things. Mm-hmm. So that's one thing. That's one. Now, this is what I was telling you about requests for admissions. A party may serve, and this is Alabama Rules of Civil Procedure. You can read your state, but it's good to know these. A party may serve upon any other party a written request for admission for purpose of the pending action only of the truth of any matters with the scope of Rule 26B set forth in request that relates to statements or opinions of fact or of the application of law to fact, including the genuineness of any document described in the request. Copies of documents shall be served with the request unless they have been or are otherwise furnished or made available for inspection and copying. So that means that you want them to bring the original to make your own copies and your own inspections. The request may, without leave of court, be served upon the plaintiff after commencement of the action and upon any other party with or after service of the summons and complaint upon the party. So again, there you go. You get the request for the admissions. And they admit they got to answer these things, whether they admit or don't admit to what the things that they couldn't produce or whatever the case may be. But that's a form of the discovery tools, or what I like to say, that you get to use. Now, failure to make discovery. So, in the motion for ordering compelling discovery. So, a party upon reasonable notice to other parties and all persons affected thereby may apply for an order compelling discovery as follow. So that's Rule 37. This is the reason why I say if they don't show, then you get to do a motion to compel. Okay? They're letting you know. It's a motion relating to discovery issues shall be accompanied by a statement of the attorney for the moving party stating that the attorney, before filing the motion, has endeavored to resolve the subject of discovery motion through correspondence or discussion with the opposing counsel if the opposing party is not represented by counsel with the opposing party. Interesting. Let's see. If the motion is granted, the court shall, after opportunity for hearing, require the party or deponent whose conduct necessitated the motion or the party advising such conduct or both of them to pay the moving party the reasonable expenses incurred in obtaining the order, including attorney fees, unless the court finds the opposition to the motion was substantially justified or that the other circumstances make an award of expenses unjust. Man. So if the motion is denied, the court shall, after opportunity for hearing, require the moving party to pay. So as y'all can see that every time a motion is made, there has to be a hearing. So understand that part too. I'm just going through some of these rules and procedures just to let y'all glance at them, but what you need to know about them. Right? Jury trial of rights. Let's see. Right preserved, the right of trial by jury, as declared by the Constitution or as given by statute of this state, shall be preserved to the parties. All right, inviolate. So you have that right. Then it says trial by jury or by court. So if it's by the court, it issues not demanded for trial by jury as provided in Rule 38 shall be tried by the court, but notwithstanding the failure of a party to demand a jury in action in which such a demand might have been made of right, the court, in its discretion upon motion, may order a trial by jury of any and all or all issues. So that means that you still can ask for one. The court, upon motion or its own initiate, may try with an advisory jury and any issue not triable or right by a jury for which a jury trial has been waived, or in case when the consent of both parties may order a trial with a jury whose verdict has the same effect as a trial by jury. And yeah, that's pretty dope. So that's fully easy to understand as well. But it's really important, guys, that you understand evidence. Evidence is very, very important. Okay? Evidence. Evidence, best evidence always rules. So be able to prove it is what you want to be able to do. Be able to prove it. Make them prove it. Remember that if they made the claim, it's their duty to prove it. All you have to do is just, well, there's no proof of delegation of authority here. This court lacks standing because there's no cause of action here to grant relief. Why? Because there's not enough evidence. This person doesn't have the right to bring this claim. They don't have delegation of authority. They lack standing. So many different reasons. But if we go deeper into it, then we're going to make them produce everything for the record, on the record. We get to see it all. We want to see it all. And we're going to fully act according to the court's laws. And that means we're going to be going according to due process. And we're definitely going to win. That's a fact. Absolute fact. Okay? So, this is what I'll do for you guys today. Go to www.ingodwetrustacademy.com. Dun, 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 dun. And what I want you to do, I have a how to stop foreclosure class on ingodwetrustacademy.com. I'm going to make that half off for you guys that's listening tonight. So I want you to send a email to admin at ingodwetrustacademy.org. Again, that's admin at ingodwetrustacademy.org. Okay. And I want you to put how to stop foreclosure half off. Okay. You will be given a discount code tomorrow. And that discount code will be given to you to go and do it half off. All right. Hope you guys appreciate this. Don't forget about work sessions. We got work sessions first thing in the AM, 11 a.m. Central Time. We got work sessions. So also, if you do email us and you're new to us, tell them that you want to join work sessions. Work sessions is free. Right now, we're in season 7. And tomorrow, we're going to be going over the writ warfare. Okay. What we're going to be going over tomorrow, teaching you guys how to do treaties of writs, how to go about knowing your writs, when to actually exercise injunctions, when to exercise mandamus, when to do those things is what we're going to be going over tomorrow. It is a full ebook coming from In God We Trust Academy, and we're going to break down each and every last one of them for you. All right. So don't forget, email us admin at ingodwetrustacademy.org. Say you want to join work sessions, and also you say that you want how to stop foreclosure for half off at discount, and you will be given the discount code. Okay. Like I said, tomorrow. So that will be email where admin at In God We Trust Academy.org. I'll put it in here for you. Maybe you'll see it. There you go. My earphone fell off. Would you repeat the email again? I just posted it for you. I'll put it over here in the chat for you guys too as well. All right. I'll put it in both. So now I pinned the comment. Make sure that you guys come rock with us. All right, send that to us. You want to be a part of the work session as well as now, and that you want the discount on there, how to stop foreclosure. If anything, man, get with your people, get with your family. Y'all just go in on it. You never know who might need it in the future. It will definitely show you how to go about those things. Work session season 6 is also half off right now, so we can't forget that. Season 6 is also half off right now. Also, credit warfare is up right now. So don't forget those things. And we also got half off on a full trust setup for you right now. And that donation is $600 to fully set up your trust the way that you want it and fully prepared. as well, with full 101 step by step on how to do, what not to do, when to do, what not to do as well. Get it while the getting is good. In God We Trust Academy.com. Again, we appreciate you guys for signing into our podcast. Catch us here at 11 a.m. Central Time in the Rising AM. And can't wait to continue to connect with you guys. Like, share, and subscribe. We do this a lot. So thank you guys for being a part of this. Anybody that just started to follow us, and we appreciate you guys, and we hope that you love it here, and we know that you will. Remember, if you heard this tonight, this was specifically for you. Specifically for you, man. Continue to grow. Time plus consistency equals growth. Believe in yourself because God already believes in you. That is the reason why you are here. Okay? You're already here. You already have purpose. Stand in that purpose. Live in it. Have the will to go. Have the courage to keep going. Do not let fear override faith. Go anyway. Go anyway. All right? Y'all have a great and beautiful night. I am out of here.